SJC-13296, Martin McCauley, v. Nelson, Alves, and another.
Okay, Attorney Harris, whenever you're ready.
Good morning, Your Honors. My name is Jeff Harris. Madam Chief Justice, and may it please the Court, I'm here representing Martin McCauley on his medical parole case. I know Your Honors have already gone through some of the issues involved in this case already. There's two issues in Mr. McCauley's case. One of them is the abuse of discretion by the DOC Commissioner. The other one is the validity of 501 CMR 1702. I think probably I should just jump right to Justice Wentland's issue, because I'm sure you all have the same question in my case. Isn't this a question of discretion? Why is this, how can we overrule not even the lower court, the agency? And I think that's the central question here, for sure. There's the abuse of discretion, and then there's the abuse of discretion. There's different kinds. In this
But
case,
don't we need the actionable kind?
yeah, I think we have all the kinds here, actually. I'll start with what I think is maybe the most straightforward, which is the agency head here needs to take into account all of the inputs that the statute requires her to take into account. One of those things, obviously, is risk assessment. Risk assessment is perhaps the most important issue, because there's no question about whether or not he is permanently incapacitated. Everyone agrees he is. So the DOC has been charged with doing a risk assessment and then taking that into account. Here, I raised that they didn't do a risk assessment, and then the DOC has said, actually, we did complete a risk assessment. I would just ask the court to look at RA 522, where I think quite clearly, in their own words, a risk assessment was not completed. I don't know, I think that speaks for itself. They didn't do it. It's something that they have to take into account when they do an analysis of a particular individual, and they didn't do it. So that's one example of an abuse of discretion. And you don't have to overrule the DOC's discretion. It's just that they didn't take into account. It's a little bit like this court ruled in Deal, where they look at the Diachenko factors that the parole board is looking at, and they say, we're not going to look into how well you looked at those factors, but you definitely have to look at them. And if you don't, that's a constitutional error. This isn't a constitutional question. This is a statutory question, but indisputably, that's something that she has to take into account and didn't bother to do. The second abuse of discretion, unless your honors have questions about that, the second...
Will you remind us what was the response of the Commonwealth on that? I thought they said that they looked at another document to measure the risk of reoffense. Is that wrong on that one? Or am I confusing with the other case?
In fact, I referred to that document as a potential risk assessment, and the DOC said, you are mistaking the classification. As Justice Kafker, as you said earlier, that is a qualitatively different kind of assessment. Now, that is all that was left up. That was all that I had to work with. And that was all that Superintendent Alves had to work with. So that's what he sent along. That's what he had. But that was clearly not enough.
You're saying, okay, regardless of anything else, they should have to redo this. You realize you're gonna just lose again if we do that, right? That
No.
They clearly have at least implicitly considered the risk of his reoffense, right?
I will tell you why they're not going to find that he has a risk. Because he has 30 years of institutional history that are successful. He has.
Well, aren't they going to say? I mean, I'm predicting what he's going to do, but aren't they going to say he did the original murder because he was in a drug-induced state, and his disciplinary history indicates problems with drugs, that are ongoing, and therefore that poses a risk, again, of criminal behavior. I don't need to jump ahead, but why don't you address that?
Yeah, I suppose there's always going to be a way to characterize the facts, some of the facts, as suggesting future criminal behavior. The man is 65. He has lumbar stenosis. He's got pain in his extremities because of neuropathy. He can't walk without a walker. He has a hernia belt. He's got all these things that are wrong with him. He also doesn't have a history that suggests any recidivism. He used drugs in prison, and that was rule breaking, and he shouldn't have done it. But as soon as he got medicated by the DOC, as soon as he got a prescription for narcotics that alleviated that pain, which is extensive, he's had 4 lumbar back surgeries. He hasn't had any problem since that time.
So we should be pressed the Commonwealth when they get up saying, look, okay, he had a drug history, but once he got permissible legal drugs, that's no longer a risk. Is that what you're saying?
That's right. Yeah.
Okay.
I don't want to get into the facts because I agree with you that as soon as I start arguing the facts, you can say, well, that's a matter of discretion, and that's fine. I don't think it's actually a close call as to whether or not there's a history of violence, what they call an extensive history of violence, but maybe that's left up to the DOC. The other abuse of discretion, which I believe is qualitative, not quantitative, but like an error of law, not just something that they did where they used their discretion wrongly, is to say that by giving someone accommodations, they have recapacitated them. And I've tried to explain this in my brief, but basically the regulation allows them to give someone accommodations who's permanently incapacitated so that they can do the things that they believe are proxies for violence. So if the person can brush their teeth, if they can toilet, if they can shave, whatever, if they can get around their cell, therefore they can do the ADLs, and because of that, they're by definition not permanently disabled. That is just wrong. I mean, as your honors, I think, have noted in your solicitation, it narrows the statute. It's like we have a group of people who should be considered for medical parole. What this does is it takes the term debilitating out of the statute and purports to redefine that somewhere else in a regulation. And that redefinition narrows the group of people to only people who can't do activities of daily living. That is contrary to the statute. I think in Harmon and in Buckman, you have said we want to broadly construe all of this.
But don't we have to consider whether something can be ameliorated in determining whether it's so debilitating that the prisoner does not pose a public safety risk? Or,
Sure.
or stated differently, is it arbitrary and capricious for the commissioner to so do?
What I think is arbitrary and capricious is to say, and which they've done, and I would point you to RA 547, where they say if the person satisfies the definition of not having a debilitating condition, if that's the consideration, whether they satisfy that definition in our regulation. If they do, then they are not eligible for medical parole. That's the error. They're not saying, do they satisfy that definition, and are they also not a risk? That would be permissible. That would be saying we're not going to narrow the statute. We're going to look at our regulation and try to determine whether or not the person can manage some of the activities of daily living. But really the larger question here has to be, are they a risk to the public? And if they're only looking at the question of ADLs, that's an error of law. That's not what the statute says. The statute says public risk. They have to figure out whether or not the person's a public risk. And the reason it's a problem here is because they don't give themselves any wiggle room. They say the reason he's not eligible is because he can do the ADLs, very specifically. And that's at 547. So I guess I've already kind of talked about both. The the first issue is abuse of discretion. I've given you 3 examples of abuse of discretion: the risk assessment, the quote violent history, and the way that accommodations really can't recapacitate someone, and the use of the regulation in that way. I think the other issue, which is sort of the same issue really, it's just the other side of the coin, is whether it's a valid statute. And I think all you have to look at is your instructions in Buckman and in Harmon to say this has to be broadly construed. You can't narrow it, and it clearly narrows the. I think what your Honor's solicitation said it exactly the way I would say it. Is it narrows the definition.
How do you measure permanent incapacitation if you don't use proxies such as ADL?
That's a very good question. In a way that doesn't narrow the statute.
Okay.
I mean, I know I'm not answering your question, but I'm not.
Whether it's reasonable for them to use that.
I think it's reasonable for them to take it into account, for sure. Whether or not someone can walk is certainly important. Whether or not someone, but I mean, think about the Alzheimer's patient, right? I think that's the most kind of quintessential example of where you can see there's a problem with the regulation because it comes to an observed result. The person can do all these things, can get around, can shuffle around his cell, and and he should be medically paroled. Everyone would agree.
Are those people not being paroled?
No, they're not being paroled because those people, the DOC will say, well, they satisfy my regulation. But I didn't write the amicus, so I don't know exactly who those people are.
I'll certainly take another look at it. But go back to the first question I asked you.
Sure.
How do we measure this?
Well, it is a question of whether or not it should be similar to what the parole board does. And they don't take into account whether someone can do ADLs. They consider broadly whether or not someone is a risk to the public. And I don't dispute that those are.
But it has to be risk to the public, no longer a risk to the public because of permanent incapacitation, correct?
Yeah. And I cannot at this pulpit right now tell you how the regulation should be rewritten, but I do know that the regulation is invalid, and there's no question about that. And that Mr. McCauley is kind of exactly the person who is suffering from the fact that the regulation was invalidly written. And with that, I stand on my brief.
Thank you. Okay, Attorney Caffrey.
Good afternoon, Your Honors. If it may please the court, my name is Stephanie Caffrey on behalf of Nelson Alves and Superintendent Carol Michi. Mr. McCauley, an inmate in general population, is not permanently incapacitated as defined by the medical parole statute, as his condition is not so debilitating that he does not pose a public safety risk. In defining permanent incapacitation, there are 2 components. First, that the inmate's incapacitation cannot be reversed. That's the medical assessment that is conducted. Second, the incapacitation must be so debilitating that the inmate no longer poses a threat to society. That is the discretionary function of the commissioner, and that's exactly what she has done in this case. The definition of debilitating condition does not constitute an impermissible narrowing of the scope of the medical parole statute, where it merely provides a global definition of what constitutes a deliberate
We understand.
debilitating condition. I apologize. Chapter 127, Section 119AH provides that the security of the Executive Office of Public Safety and Security with express statutory authority to promulgate rules and regulations necessary for enforcement and administration.
Can I ask you to apply the regulation to a patient that has Alzheimer's?
Certainly, Your Honor. So I will disagree with my brother counsel in that the commissioner will certainly, in a medical assessment that's conducted by WellPath, if there is a mental or cognitive impairment, that is most certainly considered. I can state that there have been inmates with dementia or Alzheimer's that have been released on medical parole, but again, it's looking at the totality of the circumstance. As you can see before you,
Do you have decisions that say that?
court decisions,
Or DOC decisions that say that, where it's been granted, where they have dementia or Alzheimer's?
there have been those decisions, yes, Your Honor.
And can you supplement the court with those? Because we have the cases in the amicus brief that say otherwise. I'd like to know what the universe is.
Certainly, and that's something that I can look into supplementing. The only concern that I would express is the fact that they do involve, obviously, HIPAA and CORI, so they would need to be done under
I would
a
assume you
motion
would
to seal.
redact them, right?
Yes, Your
Or
Honor.
impound them.
Can impound it.
We can impound them, right?
Certainly. In turning to the risk assessment that was conducted in this case, Mr. McCauley claims that DOC did not bother to follow its own regulation and conduct a risk assessment on Mr. McCauley. Counsel did refer this panel to the administrative record. I would suggest that there are two distinct risk assessments that are conducted. One that is conducted is the COMPASS risk assessment, which I believe is what my brother was referring to in the administrative record. Part of the package that was sent by the superintendent included the classification report, the personalized program plan. And within the personalized program plan is where the COMPASS risk assessment comes into play, as that is utilized in establishing programs for inmates. It is not conducted for those that are serving life sentences. In this case...
Okay, but I'm confused. Is there a risk assessment for this petitioner?
There is a risk assessment for this petitioner.
Where is it in the record?
I would turn the court's attention to the commissioner's decision or the superintendent's recommendation, rather, in where he conducted a risk assessment.
Your opposing counsel's comment is just inaccurate? Is that where?
That it was, I'm sorry, I didn't hear the last part of your
Was
question.
inaccurate? So there is, this is a factual issue. It's easy. There is a risk assessment here that we're going to look at, right?
Yes, Your Honor, and in the superintendent's recommendation, as noted in the commissioner's June 2020 decision, the superintendent reviewed the classification report as well as the personalized program plan, as well as observations of a unit officer, and all of those encompass the risk assessment conducted by the superintendent.
All right, so let's talk about this person clearly has debilitating conditions, lots of them. So the issue is whether with those debilitating conditions, he's no longer a risk. Tell me why he's a risk.
In terms of Mr. McCauley in particular, Mr. McCauley is able to ambulate with the use of a walker. He is able to bathe. He is able to dress himself. He is able to conduct the ADLs. Furthermore, in looking at the totality of the circumstances again, as whether or not Mr. McCauley poses a risk to society, the commissioner did note his institutional history, which involved drug use as well as an assault on staff.
So what is your response to your opposing counsel says, okay, he had a drug problem because of a pain problem, and once he got prescription medicine, that disappeared. Is that inaccurate?
That I don't see support for that allegation within the record. I believe that was...
Are there any drug offenses after he receives his prescription for painkillers?
It's my understanding that Mr. McCauley had spinal surgery starting in 2013. I believe that he also had a guilty report for Suboxone in 2016, if memory serves me correctly.
Okay, so again, it's a factual issue whether there's post-drug conduct. So then I get to the issue of the role of his crime. So he's convicted of first-degree murder, but it sounds, and he's a one-time criminal. He had no priors, and he has no crimes of violence in prison. I take in prison, right?
He has had at least one incident in which he assaulted a correction officer with a food tray.
Okay. All right. But so are we measuring a risk that he's going to get involved in drugs? Are we measuring a risk that he's going to hurt somebody again? What are we measuring? And what is the universe that we're supposed to consider there? Because it can't be all crimes. Like we shouldn't be worried about him being an arsonist, right?
And
He hasn't. I understand with Mr. Carver, he was an arsonist. We need to take that possibility into account. What do we need to take into account for Mr. McCauley?
well, in Mr. McCauley's case, it was a murder by the use of a firearm, where he shot at the victim, who was a stranger, point blank in the head.
Right. So his debilitating conditions here don't impact on his ability to use a firearm. Is that how we analyze it? I'm just trying to get a sense of what we're supposed to do.
That's certainly part of the analysis, yes. Whether he has the physical capacity to commit a crime, again, whether it be a similar crime or the same crime.
Okay, but he can't commit again. He's not going to rob any restaurants anymore, right?
I can't definitively answer that in the affirmative.
Well, he doesn't have the physical capacity to move quickly, right?
Yeah, I mean, it is noted within the superintendent's recommendation. The unit officer did note that Mr. McCauley was known to frequently walk outside with the walker, but that he was able to move quite quickly.
We don't have many bank robberies with walkers, do we? Or restaurant robberies with walkers?
That I cannot answer.
Counsel, could I follow up on Justice Kafker's point, because it goes back to the prior case too? What are the rails for the superintendent when if we're trying to evaluate the discretion and whether there was any abuse? What are the rails to that consideration for the superintendent? Is it because there's always some potential hypothetical or conceptual crime that they could commit? So how do we gauge that? Let's take Mr. McCauley's condition. Your opposing counsel said that the drug issues were related to pain. So I'm going to assume that they're heavy-duty drugs to ameliorate his pain. So let's just say that you could say conceptually, he's got a prescription for Suboxone. He's got a prescription for really heavy-duty pain medications that could be really valuable on the street. And so now we say, well, if we released him and he's got this prescription, he could be selling his pain medication. How do we gauge that? Because I think that's the point of Justice Kafker's, and I think we all have the same consideration. If it's not apples to apples, and he's no longer a bank robber, he's no longer a murderer, there's still a universe of crimes that he could commit in his current condition. So how do we measure that?
And that is correct. And to your point, the focus is sometimes on whether or not the inmate is committing violent institutional offenses. In Mr. McCauley's case, he was committing drug offenses, and he continued to violate the rules and regulations of an institution. So that is, again, taken into consideration when looking at the totality of the circumstances and the risk that the inmate poses to society.
So that could always be a factor that would work against an applicant, wouldn't it?
It could be. It could be considered. And again, in medical parole petitions, they are very, very individualized. Again, the record in this case is over 600 pages. They are very fact-intensive. There's a lot that goes into the review of them. So the commissioner looks at the totality of the circumstances in determining whether or not a person poses that risk to society.
But the question is, how do we decide, how do we figure out whether the choice made by the superintendent is an abuse of discretion? Sounds like you're saying it won't be because she's doing what she's supposed to do.
Well, I think that the record shows that there is substantial support for the decision that both the commissioner made and the recommendation that the superintendent made.
So I guess the problem is there's terminal illness, which we don't have, but then there's incapacitation. And unless someone has Alzheimer's, dementia, or is incredibly incapacitated and bedridden, there's this group of people, which I think these last two defendants fall into, where hypothetically you could commit a crime. I mean, anybody that's in a wheelchair and a walker could commit, any type of crime. They could be on the phone and, doing scamming people. So there's always a hypothetical crime that could be committed. When is it an abuse of discretion for the commissioner to say, well, they could commit a crime because they don't have Alzheimer's or they're not bedridden?
And I think that's where it becomes, again, the individualized assessment, where you're looking at the institutional history, the index crime of that particular inmate, any offenses that they committed while they were incarcerated. I think that that's where all of those analysis come in as well.